Well-respected and learned brothers and sisters, this is Advocate Devmorari talking to you from Ahmedabad city, Gujarat state, India, that is our Bharat. Today I have selected a very good topic, intelligent topic from Bharatiya Nyaya Sanhita 2023, and the topic is BNS section 109, attempt to murder, and BNS section 118, voluntary causing grievous hurt by dangerous weapons or means. I have discussed distinction between these two. First of all, let us see BNS section 109, attempt to murder. I'll read out subsection 1. Whoever does any act with such intention or knowledge and under such circumstances that if he by that act caused death, will be guilty of murder, shall be punished with imprisonment of either discretion for a term which may extend to 10 years and shall also be liable to fine, and if the hurt is caused to any person by such act, the offender shall be liable either to imprisonment for life or to such punishment as herein above mentioned. Subsection 2. Section 2 of section 109 of BNS. When any person offending under subsection 1 is under sentence of imprisonment for life, he may, if hurt is caused, be punished with death or with imprisonment for life, which shall mean the remainder of that person's natural life. So till he dies, he will be in jail. Ingredients and burden of proof. The burden is on the prosecution to prove both the act, that is actus reus, and the intention, that is mens rea. Now, what is intention? I may sum up in one sentence the meaning of intention. Intention is the association of will going with the act of the person. That is intention. To charge a person under BNS section 109, it has to be shown as to what was the actual intention of the assailant and also as to what is the nature of injury, that is, the extent of damage caused to body or any organ thereof. Simply because the injury was caused with a sharp-edged weapon and was in the head, that is a vital part of the body, the same fact by itself, in absence of any evidence about existence of any fracture or any X-ray report in support or evidence about examination of the injury by the doctor would not be sufficient to declare the same injury to be dangerous to life so as to justify BNS section 109 or 118. Neither of the section can be justified. When can accused look for acquittal? But the story of the prosecution was not corroborated by the medical evidence that the prosecution could have lost his life as a result of injuries inflicted by the accused. The conviction of the accused for offence under BNS section 109, that is attempt to murder, would be quashed. If the assault did not produce any injury on vital part of the body of victim, an inference that the assault was aimed at causing death of the victim would be improper, and the conviction of the accused under section 109 of BNS would be set aside. Except injured person, now this is the situation, except injured person, all other witnesses are hostile. Then what will happen? The answer is Unless there is any plausible explanation of injury cannot be brushed aside on the ground that he was a lone person to depose about the occurrence and others were claimed by the prosecution to have witnessed the occurrence did not support the prosecution version and were declared hostile. Please remember, let there be witness only one injured person's testimony. What is the value of this? Please remember, in a case where injuries are inflicted, the crucial testimony is of the injured person. Yes, because we have borne the impact of the quarrel. So that is very important. Let there be other witnesses hostile. Now I'll give one illustration. Say, he intending to murder Jared buys a gun and loads it. What is the offense? He has not committed any offense because he has not acted. He fires a gun at Jared. Here he has acted. He has committed the offense defined in BNS section 109. And if by such firing he wounds Jared, he is liable to the punishment provided by the later part of section 1 of section 109 of BNS. Now what is the later part of the subsection 1 of section 109? I'll read out. This is the later part I'm reading. And if hurt is caused to any person by such act, the offender shall be liable either to imprisonment for life or to such punishment as is here in before mentioned. Now, if injuries were not caused with intention to cause death, conviction would be under section 326 and not under section 307 of IPC or this BNS 109. Though the sharp edged weapon was used, the injuries were not caused with an intention to cause death and were not sufficient to cause death, can fall within the four corners of section 118, not under section 109. So attempted murder. It will not be attempted murder. Now, the distinction between attempted murder and grievous, voluntary causing grievous hurt by dangerous weapons or means. We already discussed here section 109, attempted murder in detail in this video. Now let us address first of all what is meant by hurt. What is the meaning of hurt? BNS section 114 defines hurt. It reads, whoever causes bodily pain, disease or infirmity to any person is said to cause hurt. The meaning of hurt. The term hurt simply means performing an act which leads to physical pain, injury or a disease to a person. At times hurt may be caused voluntarily or it can be caused by using dangerous weapons or means. Now BNS section 115, voluntary causing hurt. Subsection 1, I'll read out. Whoever does any act with the intention of thereby causing hurt to any person or with the knowledge that he is likely to cause hurt to any person and does thereby cause hurt to any person is said voluntarily to cause hurt. This is the meaning of voluntary causing hurt. Now subsection 2. Whoever except in the case provided for subsection 1 of section 122. Here references made to the section 122, otherwise I will say what is it. Voluntary causing hurt shall be punished with imprisonment of either description for a term which may extend to 1 year or with fine which may extend to 10,000 rupees or with both. Here section 122, what does it say? Subsection 1 and 2. Voluntary causing hurt or grievous hurt on provocation. Explanation. This section is subject to the same proviso as exception 1 of section 101. Now the defense law you have to refer all these things. That is I am referring. Now let us refer exception 1 of section 101 of BNS. Now let us see what exception 1 of section 101 says. BNS section 101 deals with murder. Exception 1 reads, culpable homicide is not murder if the offender was deprived of the power of self-control by grave and sudden provocation, if he acts, which is the death of the person who gave the provocation or causes the death of any other person by mistake or accident. Now there are 8 kinds of grievous hurt. I'll read out. The following kinds of hurt only are designated as grievous hurt. There are 8. Number 1, emasculation. Then permanent privation of the sight of either eye. Permanent privation of the hearing either ear. Privation of any member or joint. Next, destruction or permanent impairing of the powers of any member or joint. Next, permanent disfiguration of the hair or face. Fracture or dislocation of bone or tooth. Any hurt which endangers life or which causes the sufferer to be, during the space of 15 days, severe bodily pain or unable to follow his ordinary pursuits. Now suppose Mr. A, he says that for 15 days he didn't go for his work or suffers bodily severe pain. Can you believe? No, sir. Now here this is simply given in BNS, but according to me, this is not sufficient. There is lacuna in this section. What is that? If a person takes treatment for the injury as an indoor patient in a hospital, government hospital, then God should believe that he has suffered severe bodily pain, otherwise no. I think our learned brothers will interpret this or will take the matter with the Bar Council and accordingly with apex court. Because this is to be stated that he has taken indoor treatment for 15 days, then only it can be called grievous hurt, otherwise not. Otherwise anybody can bluff just to punish. Now this I express my views. I may be wrong or I may be right. BNS section 117, voluntary causing grievous hurt, subsection 1. Where voluntary causes hurt, if the hurt which he intends to cause and knows himself to be likely to cause is grievous hurt. And if the hurt which he causes is grievous hurt, is said voluntarily to cause grievous hurt. Explanation. A person is not said voluntarily to cause grievous hurt except when he both causes grievous hurt and intends and knows himself to be likely to cause grievous hurt. But he is said voluntarily to cause grievous hurt if intending or knowing himself to be likely to cause grievous hurt of one kind out of 8. He actually causes grievous hurt of another kind. Now illustration is given in BNS section. There are 4, but I read out number 3 and number 4 illustration. That is to be attended, that we have to pay attention to that. I continue, they are serious illustration. Now illustration number 3. Whoever commits an offense under subsection 1 and in the course of such commission causes any hurt to a person which causes that person to be in permanent disability or in persistent vegetative state shall be punished with rigorous imprisonment for a term which shall not be less than 10 years. The punishment is 10 years, but which may extend to imprisonment for life. This shall means imprisonment for the remainder of that person's natural life. So we have to take care of this. But illustration 4 is very serious. I'll read out. Please pay your attention to this. Lend your ears to me. When a group of 5 or more persons acting in concert, group of 5 or more acting in concert, causes grievous hurt to a person on the ground of, now grounds are given, different grounds are given, on the grounds of his race, caste or community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be guilty of the offense of causing grievous hurt and shall be punished with imprisonment as a description for a term which may extend to 7 years and shall also be liable to fine. So always keep these grounds in mind. Now there is section 118. Voluntary causing hurt or grievous hurt by dangerous weapons or means. It reads subsection 1. Whoever except in the case provided for subsection 1 of section 122, again 122 comes here. Voluntary causes hurt by means of any instrument for shooting, stabbing or cutting, or any instrument which uses as a weapon of offense is likely to cause death, or by means of fire or any heated substance, or by means of any poison or any corrosive substance, or by means of any explosive substance, or by means of any substance which it is deleterious to the human body to inhale, to swallow, or to receive into the blood, or by means of any animal, shall be punished with imprisonment of the description for a term which may extend to 3 years, or with fine which may extend to 20,000 rupees, or with both. What will happen to the poor man? 20,000 rupees fine. So section 2. However, except in the case provided for by subsection 2 of section 122, voluntary causes grievous hurt by any means referred to in subsection 1 shall be punished with imprisonment for life, for the imprisonment of the discretion for a term which shall not be less than 1 year, but it may extend to 10 years and shall also be liable to fine. Now I'll discuss in short. This is in a descriptive manner, but now I'll give chronological order. Ingredients to establish offense. The following ingredients are must to establish the offense of grievous hurt. Now, these are the ingredients of grievous hurt in short. Number 1, voluntary hurt caused to another person by the accused person. Number 2, and such hurt was caused A, by any instrument used for shooting, cutting or stabbing, or any other instrument likely to cause death, or B, by fire or other heated instrument, or C, by poison or other corrosive substance, D, or by any explosive substance, or E, by a substance that is dangerous for the human body to swallow, inhale, or receive through the blood, or last F, by an animal. Then is section 118, subsection 2. Now there is subsection 2 of then section 122. It is, whoever voluntarily causes grievous hurt on grave and sudden provocation, if he neither intends nor knowledge nor knows himself to be likely to cause grievous hurt to any person other than the person who gave the provocation, shall be punished with imprisonment over the description for a term which may extend to 5 years, or with fine which may extend to 10,000 rupees or with both. Explanation. This section 122 is subject to the same proviso as exception 1 of section 101 of BNS. Now read out BNS section 101, exception 1. Culpable homicide is not murder if the offender was deprived of the power of self-control. He loses self-control. How? For what reason? By grave and sudden provocation. If somebody excites him by grave and sudden provocation, causes the death of the person who gave the provocation, or causes the death of any other person by mistake or accident, then it is not grievous or it is not murder. Then punishment will be very less, or he can use self-defense also. Hope you have nicely understood the distinction between BNS section 109 attaining to murder and BNS section 118, one is causing grievous hurt by dangerous weapons. So means hope you enjoy this video, you have got some useful information. Thank you very much for joining with us. If you are new, please subscribe it. If you already subscribed it, like it and share it. Thank you, thank you, thank you.